Hold on. Yeah, you can talk. We're live now.
Good day and welcome to today's webinar on company director changes and close corporation member changes. My name is Elma Pinkham and I will be the facilitator for today's program. Our presenters are both from the directors, members and authorized representative unit. They are Thomas Lebetti, a manager who will present on company director changes, and Pieter Engelberg, a specialist advisor who will present on CC member changes, as well as the requirements for certification of ID copies. After the presentations, there will be a question and answer session. During the webinar, you are welcome to post your questions related to today's topic under comments. We will respond to these questions. If you have questions that are not related to the topics, please log an inquiry on the CRPC website, inquiry system, or send a message on CRPC Facebook with Messenger. The recording of the webinar will remain on YouTube should you wish to view it again. So on today's agenda, we will first look at company director changes, then at CC member changes, and lastly at the requirements for certification of ID copies. I want to hand over to Thomas Lebetti for his presentation. Thank you, Thomas.
Thank you, Elma. My name is Mashudu Thomas Livete. I'm a manager in the unit that deal with the change of company directors. So today we are going to look at exactly what is required whenever you want to change the company directors, because we have a challenge whereby it seems we are not on the same page with our customers outside, whereby documents are always rejected due to non-compliance. So we just want to clarify what actually needs to be done whenever you file the application so that you can get your application approved without having any challenges. So I will take you through the slides so that you can understand how CIPC operates whenever the directors have to be changed, and then we can get the questions later on so that we can get more clarity on the issues that you might have. So just to kick off with the presentation, I'll just indicate the mandate that we are expected to comply with. There are certain acts within the Companies Act that assist us to process the applications. It's from Section 66 to Section 78 of Companies Act, whereby it gives us actually what need to be done, what need to be complied with by the customers. If we can look specifically on Section 70 that deals with the vacancies on the board, and then also Section 71 that deals with the removal of directors, and then Section 74 deals with the directors acting other than at a meeting, and Regulation number 39, it's a directors and register of persons disqualified from serving as a director. So these are some of the sections that will assist us to understand how a change of directors need to be done. Moving forward, whenever there is a need to change a director of a company, remember actually there must be a vacancy that has existed in the company. Once that vacancy has existed, is then that the company need to file relevant documents to CIPC to record the change of company directors. So what actually happened is that you will be required to file the application either on a manual process, or you can use the e-services transaction to submit the document, or you can upload your documents on the website. So here we have got the email addresses that you need to use in order to get your application get to CIPC. So if you have filed the manual CR39, this is the email address that you need to send the documents to. So if you have transact on the e-services, then this is the email address that you need to use. So don't use the manual email address submitting the e-services document, because that one will not get processed, or vice versa. So, or else you can upload the document on the website. There is a specification on the website whereby you can upload your documents that you need CIPC to record the changes on. So when we move to the next screen, we have the supporting documents that are required. So this is a very important slide, because normally documents are rejected based on the non-compliance of these supporting documents. So you need to ensure that whatever is required here, it's also submitted when you file the application. So for both manual and e-services transactions, we will need the minutes of the meeting whereby the decision was taken to change the directors, or the resolution that has been taken to change the directors. It can be the round robin resolution, or the minutes of the meeting signed by all directors as required by the practice notice number 1 of 2019. Or we also need the certified ID copies of all directors who are affected by the change. And then meaning that whoever is coming in as a new director or is going out as a director, we will need the certified ID copy of that person. But for the remaining directors, you don't need to file their ID copies. We only need ID copies of those directors who are affected by the change. And the certified ID copy of the applicant must also be filed. That is the person who has been asked by the company to file the application on behalf of the company. That is a third-party person. And then in case of a deceased director, we will require the death certificate to ensure that we record the correct information on our system. And then we'll also require the appointment letter or resignation letter signed by affected director as required by practice notice number 2 of 2021. This is very much important, because the reason that we have requested this last paragraph, the appointment letter, is because only on the resolution, previously, remember, we used to accept the resolution specifying that so and so has been appointed, so and so has resigned. But we find that after we have processed the application, the company may come back and say, no, but we didn't file this application. And then we are not even aware of these minutes of the meeting. So it's then that we felt that we need to request the additional requirement in terms of the appointment letter to ensure that the person has accepted to be appointed as a director, or the person has resigned as a director of the company by submitting that resignation letter. And then the next slide here is for the manual application. This is the very document that people normally made some errors when they file the manual application. In most cases, we find people submitting only the first page for all directors, which is wrong. So if there are more than 2 directors or more than 1 director, then it means that the first director will be completed on the first page, and the second director details will appear on the second page. If there are more than 2 directors, then each director's details should appear in one block. You will see that these numbers, 1 up to 12, you can refer to the first page where there are the notes guiding you what need to be completed at number 5, what need to be completed at number 9, what need to be completed at number 6, just like that. So you just need to complete the details of other director in one block using the notes on the first block. You don't need to file one page for all maybe 5 directors. That is wrong. So we normally get this error that has been committed by the client, and then we end up not approving the application. Then for processing the manual applications, once we have received the manual application, using this email address, as I've indicated earlier on, we will receive the manual application and then we will allocate the tracking number in the office, which differs with the e-services tracking number, because the e-service tracking number starts with 9. And then in the office, we use this type of tracking numbers. So the documents will be allocated tracking numbers to verify that we did receive the documents. And then there will be in a box that has been tracked on the day. And then from there, the box will be opened, will be closed. And then those documents will be distributed to team members who are going to do the capturing of all the changes that you have indicated. If there is a new appointment, then they will capture the details of that new person who has been appointed. If somebody has resigned, then they will also change the status of that person from active to resigned. And then those team members, they are the ones who are responsible to capture all the changes that you have referred to on that application. So once they have done so, the outcome of that application will be dispatched to the email address linked to the customer code on the form. Because when you filed this manual CR39, there is a block on top where you need to complete the, excuse me, where you need to complete the customer code. So that customer code is linked to the particular email address, so that once the application has been processed, the system automatically will dispatch whether it's the certificate or the query document back to the customer on the email address that has been linked to that customer code. So it's very important that you need to indicate the customer code on top of the document, because otherwise we won't be able to process that application. That is on the manual side. So when we come to the e-services transaction, this is handled by the customer themselves. They will have to capture all the changes on the website, indicating whatever that they want to change. And then once you have done the capturing, CIPC will send the document with the tracking number on top, reflecting all the changes that the customer has completed on the document. And then that is the document that needs to be signed. And then after being signed, it will be sent back to CIPC on the e-services email address that I've indicated in the earlier slide. It's e-services cor39@cipc.co.za. So the document should be sent to that email address. And then when you file that application, you need to highlight the tracking number on the subject field of the email, so that the system can be able to read the tracking number, and the whole document will now be now in our system. So once we have received that application, the people who are going to examine the applications will open the tracking number on the system and then start to examine the application. And then once they are satisfied that you have complied with all the requirements, and then they will just go and select the button that shows approve. Then the transaction is done, and then automatically the system will dispatch the certificate back to the customer. So you need to ensure that whatever you have captured is correct, because once you have made some mistakes, CIPC cannot correct those errors. We can only correct the errors on manual applications, because that is done by our staff members. So for e-services, you need to ensure that the information that you have provided is true and correct. And then you also need to make certain that the status that you have indicated also go hand in talks to the resolution, because we find a situation whereby the CR39 form will show that the director has resigned, But when we go to the resolution or minutes of the meeting, they show that the director has been removed. So removal and resignation is not the same thing in terms of Companies Act, because a person can be removed for committing misconduct such as theft or fraud or whatever reasons. So the directors or maybe the shareholders may feel that we need to remove this person because he is against the company laws. So when that person has been removed, there is a certain process that needs to be followed that we are still going to discuss. And then it is not the same as the resignation, because resignation happens voluntarily. And then the person will decide to resign from the company, will hand over the resignation letter, and then a particular process needs to be followed in order to resign that person. So it is not the same as removal. So whenever the application is completed, it must be the resignation on the form and the resignation on the resolution, not vice versa, whereby we find the removal on the other side and the resignation on the other side. So if the application doesn't comply, then the examiner or the team member who is processing the application will just select a reject, and then from there indicate the reasons for rejection so that you can be able to respond on the query. And remember that when you respond to the query after the application has been rejected, you don't need to file the very same tracking number, because the system has already read that tracking number and then it has already released that tracking number out with the query. So you cannot resend the very same tracking number that has been rejected from the system. So you need to capture a brand new application whereby you will get a new tracking number and then file the new application, including the providing the documents that were not provided in the previous transaction. Let's say, for example, in the previous transaction, you didn't file the certified ID copy of a director. You don't, when you respond, you don't only send us the certified ID copy. You just need to submit a brand new document with all the documents that are expected to be submitted. This is the e-services transaction. Then we come to the removal of a director. The removal, as I've already indicated, and the resignation is not the same thing. Then the removal must be done in accordance with Section 71 of Companies Act, whereby a person who needs to be removed should be notified first within a certain period, maybe a 10 days period, so that that person can be able to prepare, meaning that the company should provide proof that a notice has been sent to the affected director, whereby the director was informed that there will be a meeting on this date, at this venue, at this time, whereby we are going to discuss your removal. And then the reasons for removals also need to be highlighted in the notice so that that person can be able to have chance to prepare a response on the day of the meeting. You don't have to say, no, we're going to remove you, and then because we don't like you. No, it doesn't work like that. There must be a valid reasons why this person needs to be removed. And then the removal will be, it can be done by the shareholders or it can be done by the board of directors. But there are certain limits whereby the board of directors can act on removing the director. For example, in a company that has fewer than 3 directors, let's say the company has got 2 directors, and then one director cannot remove the other director. If maybe the other director feels that this person needs to be removed based on specified reasons, then such matter should be referred to company's tribunal for determination, because one person cannot remove the other director. But in case of the shareholders, remember, they are the owners of the company, and then they can remove the director at any given time. They don't have to refer the matter to company's tribunal. They can remove the director if there are valid reasons to remove the director. They don't just need to remove for the sake of removal. There must be valid reasons that this person need to be removed. So a director may be removed by the board or shareholders for committing misconduct such as theft, fraud, forgery, or neglecting his functions as a director. So if a person is not performing as expected, so the shareholders have got the right to remove that person as a director. So the application and resolution must have the same information as I've already indicated, that we don't need to see the removal on resolution and resignation on the form or vice versa. And then such a notice will be, no, the resolution signed by authorized directors objecting such, oh, sorry. Since there is a notice must be sent to the affected director with reasons for removal, as I've already indicated that the person need to be given reasons why he need to be removed so that he can come and answer on the day of the meeting, or he can send a representative to come and represent him in the meeting. And then after the meeting, then there will be a vote whereby people will vote for the removal or vote against the removal. And then based on the majority of votes, then that person, if maybe majority of people voted for his removal, then that person will be removed as a director of the company. So we also have the removal of an authorized director. In this case, you find a person has been removed from the company without their knowledge. This can happen, but whenever you have to file the objection of that transaction, it should be done within the 10 days period after the change has been registered. And then you will need to file COR 168 form to challenge that transaction that happened, because we receive a lot of complaints whereby people will come and say, no, I have been removed from the company. I don't even know who removed me. There are people who are now active directors in my company. I didn't give an authorization for that. And then we ask these people to file COR 168, but this should be done within 10 days period. So if maybe they come and challenge the filing after the 10 days period, then they will have to file COR 39 form, not COR 168. They will have to file the manual COR 39 that I have indicated in the previous slide. At number 12 at the bottom of each block, where you have to indicate the status of the person or the nature of change, that is where you are going to indicate remove an authorized appointment, so that we can see that the removal that you are referring to is not in line with the section 71, whereby you have to send a notice to the affected person to be removed. In this case, you don't know the person. We are not expecting you to send a notice to the person, inviting that person to come to the meeting. In this case, this is a different removal, whereby that is why we said you need to indicate this is an unauthorized removal so that we can record it as such. When you have to submit the CR 160, I mean the CR 39, you will need to file the resolution signed by the directors, objecting that they don't know anything about these directors who has been appointed, or maybe the person who has been removed, and then they are against that removal. So they need to file the resolution indicating that they are objecting for that change of director. And then this one we have already touched on. It's the resignation or appointment of a director, because you will remember that the vacancies arises within the company due to various reasons. It can be the resignation, incapacitated of a director who is no longer able to work. It can be due to death of a director. It can be the expiry of the term of office. It can be retiring at the end of the term. So those vacancies need to be filled within 10 business days by filing the CR 39. So in case where the director has resigned, as I've already indicated, he must hand over the resignation letter, And then in case where the new director has been appointed, he must also submit the consent letter to accept being appointed as a director of the company. So remember that in this situation, we don't need a person who should be appointed and then without knowing that he has been appointed in the company. That is why we need the consent letter or the resignation letter of the outgoing director. So as I've indicated, the resolution of minutes must indicate the same information as it appears on the form. If it's a resignation on the form, it must also be resignation on the resolution of minutes of the meeting. And then we have the disqualification of a director. So in most cases, we find people will file the application and indicate that Director A has been disqualified. So that one is not acceptable. The company cannot disqualify a director. The director is disqualified by the court. So once a person has been declared delinquent director, so the court will file the court order to CIPC so that we can record that person in the disqualified directors register at CIPC, so that that person can no longer be able to be associated with any company. He cannot even open a new company because the moment you put in the the ID number, it will show that this person has been disqualified, and then which means that you need to be rehabilitated first before you can qualify to be appointed as a director again. So there are certain reasons that can lead to disqualification of a director. And then once we receive that court order from the court, we send out the letters to all the companies whereby that person is still listed as active director to inform them that this person is no longer qualified to continue to act as a director of the company, which means that that person needs to be removed from the record of that company. For all the companies where he has still been listed as an active director, up until such time when that person is fully rehabilitated. Normally, it takes about 7 years to be rehabilitated and then and qualified to act as a company director again. So once the person has been rehabilitated, we still need the court order that shows that this person now has been fully rehabilitated, and then he qualifies to be appointed as a director of any company. Is then that we will remove the details of that person from disqualified register at CIPC, so that that person can continue with his life moving forward. So the processing times of the applications, we just need to make sure that people understand how we process the application within the organization, because at some point people file the application now. The moment they submit on the QRS inquiring how far is the process. It doesn't happen like that. You cannot submit the application now and then later on during the day you file on the inquiries just to find out how far is my application. We have got the processing times for each and every application. On the manual application, then we have got 5 business days turnaround time, which means that after 5 days, if you haven't had anything from CIPC, is then that you can now make follow-up as to how far is the process of my application. And then on the e-services, it's 3 days, business days. After you have filed the application, after 3 days, then you can make follow-up if you haven't received any feedback from CIPC. So at some point, you'll find that we have a 1-day turnaround time whereby you file the application in the morning, maybe later during the day, it is approved. Then that is a bonus to you, because you are not longer going to wait for the turnaround time, because the application was processed sooner than the turnaround time. So it doesn't mean that each and every time when you file the application, that will be the turnaround time. So we have got a standard service delivery whereby the application will have to wait for that period before they can be finalized. So we encourage customers to file on e-services because this is much quicker, and then it also eliminates the errors because you are the one who is going to complete the details of the change of directors other than the manual application that is captured by our internal staff. So if you have done e-services, it goes much quicker than the manual transaction. So followed here is some of the practice notice that you need to comply with, that you need to read, so that whenever you file the application, you comply with some of the notices that I've indicated here. I've just attached them, but I cannot go through one by one due to time constraint. But these are the notices that you need to read in order to familiarize yourself with what needs to be done whenever you file the application. So in terms of the presentation, I think that's my story.
Thank you very much, Thomas. I think we must just stop sharing. And then we can share from this side Peter's presentation. Okay, I've started sharing her presentation. She will be doing it from my computer. Before she starts, I just want to make everyone aware, there is a note that on the comments that says the presentation will be shared on the CIPC website under webinars. That is so. But in the meanwhile, if you want us to send it to you, you can also send email to education@cipc.co.za and we will forward you the presentations. You're welcome to do so. But then I want to hand over to Pietro. Thank you, Pietro.
Thank you, Alma. I'm Pietro Engelberg. We'll be talking about the CC member changes. So on my first slide, I have indicated the sections of the acts that's applicable to the registration of the CK2. It's Companies Act, Section 187, subsection 4D. And then the sections applicable to it's from the Closed Corporations Act, Act 69 of 1984. So the registration of the CK2 for membership changes is not done it's done in terms of the Closed Corporations Act, and it is different from the requirements of the Companies Act. Also applicable is Regulation 2 and 16. So for these two channels to submit CK2 documents, first a document can be submitted manually. A manual CK2 can be completed. Usually we require that manual CK2 must be submitted if a trust is a member on a CC. It can also be submitted on e-services. When you submit a document on e-services, you will send the documents to e-services ck2@cipc.co.za, or the documents can be uploaded on our website. So for manual and e-services CK2, the supporting documents required will be a written instrument signed by all members, including the new members consenting to the changes. So it can be in the form of minutes, agreement, resolution. If there's minutes signed by only the active members and the new members have given you the letter to accept the appointment, then you attach the minutes signed by the active members and the appointment letters where the members have accepted the appointment. So it can be any written instrument, but each person that is a member of the CC, whether active or resigning, must attach a document. All the members must attach a certified copy of their ID and a certified copy of the applicant. The customer code owner's ID must also be attached. In a case where there's a deceased member, we require a letter of executorship issued by the Master of the High Court. The executor will sign the CK2 on behalf of the person that has passed away. So on the e-services CK2, you will capture the status of the deceased member as deceased, and the executor will sign on the block allocated. On a manual document, the details of the deceased member will be completed on page 3 for persons who cease to be members, and then the executor will sign there. A certified ID copy of the executor's ID will be required. There's no process for removal of a member. If there's a removal is required, so for example, any of the members cannot be reached to sign the CK2 and to provide the supporting documents, or the person refuses to sign a CK2, then the CC will need to obtain a court order to make any changes. So this is what the manual form looks like. It's important to remember that on the manual CK2, you have to indicate your customer code. It's the space provided client reference. All the information on the CK2 must be completed. And so on page 2, the details of all the active members will be completed. If we go to page, so this page 3 that is on here, if there's only 4 members, you will only complete the first page with the 4 blocks, and this page with the 6 blocks can be omitted. And then if there's any member that has passed away or is resigning, then the page 3 will be for persons who cease to be members. For processing of manual documents must be emailed to manualck2@cipc.co.za. Once received, the tracking number is allocated. Outcome will be a certificate or query letter, and it will be dispatched to the email address linked to the customer code on the form. If the document is queried, the whole application must be resubmitted for processing. We cannot accept it if you only send the one document that we have required, or you have corrected and you send only a part of the application. The whole application must please be resubmitted. So on e-services transactions, I've just included some screenshots to show how it's done. So firstly, you will go to e-services on our website. You will log in as a customer. You will go to transact and then to amend CC member details. First, you have to type in the CC registration number. So you will type in the format the year, then the middle digits, and then 23. So sometimes you might mistakenly go to director changes, then it won't accept. You have to be sure to go to membership changes. And if you have the number with the B in front, you leave out the B. And then, so first 4 digits will be the year. Then you have the middle part of the number and 23 at the end. So first, it will ask you the ID now to confirm the ID number of the first listed member. If the member member's ID is incorrect on our system, you have to enter the ID number as it reflects on our system at the moment. The system will compare the ID number that you enter here with what we have on our system at the moment. If it needs to be corrected, then you can edit it later when you are busy editing the details of the member. So after you have continued here, you've entered the ID number and continue, then first step will be to add any new members. So you will either click on add new member if there's a new member, or no new members. So to capture, if you add on a new member, it will ask you the details, the name, surname, ID number, the addresses of the member, and you will save the details. Then it will ask you to update the details of the existing members. So you will click on edit. If the if the date of birth or the date of appointment of the member is omitted, then the system won't allow you to continue. Then please log an inquiry on our inquiry system for us to update the appointment date or the date of birth of the member. That will enable you to continue with the lodgement. So after you've edited the details, you save it, and then you will continue. And the last step will be to indicate the contribution and interest of the members. Then you can lodge, and the system will allocate a tracking number. And after the tracking number has been allocated, each member will receive a notification of the submission via email and SMS. An email is sent to the customer that was logged in, providing the CK2 to be signed and indicating the requirements for the submission of the CK2 and supporting documents. For example, that when you submit the documents, it must all be in PDF format. It must all be on one email. You cannot send it on separate emails. And the tracking number of the CK2 must be used as the subject of the email. If the customer did not receive the document, it can be requested under disclosures or certificates and resend member amendment application form. Unfortunately, we cannot resend it to you from outside. You have to request it on our website. So to submit the documents, the signed CK2, signed by all the members, and supporting documents can be uploaded on e-services, or it must be emailed to eservicesck2@cipc.co.za with tracking number as the subject of the email. For trust as members of the CC, the CK2 must always be submitted manually. The documents to be submitted is listed on Practice Note 1 of 2006. It's a copy of the letter of authority issued by the Master of the High Court, a signed special power of attorney by each of the trustees, appointing one of them as the representative of the trustees, a certified copy of the sections in the trust deed defining or identifying the beneficiaries of the trust. So the beneficiaries are counted as together with the members, are counted as the members of the CEC. So when you add the beneficiaries to the members of the CEC, it may not exceed 10. And another requirement is that a juristic person may not be a beneficiary of that trust. If a juristic person is a beneficiary, then the trust does not qualified to be appointed as a member of a CC. The fourth document is a letter from the representative trustee in which he furnishes the name, registration number, and address of the trust, the names of all the trustees, the number of beneficiaries of the trust, current at the date of the letter, and particulars of all the beneficiaries named in the trust deed. So, and then lastly, the processing times for manual securities, the processing time for manual applications is 3 business days, and for e-services applications, it's 2 business days, the standard, the service delivery standard, but it is done within a day. And that's the presentation from my side.
Okay. I'm just going to stop sharing this one, and then we'll share the one on certification of ID documents. If I can just ask Pietro also to take us through this document, please.
Okay, so there's a lot of the documents being queried for the certification of ID copies that do not comply. There was a practice note 2 of 2022 published, and we just want to bring it to your attention. The requirements, the practice note is available on our website under legislation, and then you go to practice notes. So most important is to remember that the certification may not be older than 3 months, and the Commission of Oaths must state the date on which the document was certified. When the Commission of Oaths certify a document, he must include the following information, and the information of the certification and on the ID copy must please be clear and legible. So the Commission of Oaths, we need to know his full name and surname, his business address, he must sign, signature must be there, his designation. The documents certified by police officials must also indicate the person's rank and rank number, and the date of certification must be indicated. I think that is most important. The practice note is available on our website if you want to have a look at it again, but there are a lot of documents being queried, and that's why we wanted to bring this practice note to your attention.
Thank you very much, Pietro. I'm going to stop sharing, that we can start with our question and answer session. We're just waiting for our technical assistants to add the questions to the screen, and then we can start with that. If you request the presentation from education@cipc.co.za, we can also send you a copy of that information on certification of ID documents. Okay, our first question here is, which directors signed the resolution? All the directors? Does this include the new directors? Thomas?
Yeah, the resolution needs to be signed by the existing directors. If the new director is also available, just one second. because the chairperson who was chairing the meeting is the one who can sign the minutes of the meeting. But if it's the resolution that has been taken with the directors, um, all the directors will sign the resolution to confirm that they agree with the content of the resolution.
Okay, thank you. Somebody asked, I want to cancel a partner of which is also a director. Thomas, can you assist us with that question?
You cannot cancel a partner within the company. The person needs to resign. If you want to resign, to remove that person, then there is a process that needs to be followed, which is Section 71, whereby that person needs to be notified of the intention of his removal. And then he also needs to come to the scheduled meeting whereby people are going to vote for his removal. And then you need to be given enough time with the reasons, clear reasons why he's going to be removed. So on that day of the meeting, he will come. You can send a representative to come to the meeting to represent him or her. And then based on what has been discussed in that meeting, is then that the resolution will be taken whether to remove or to not to remove that director based on the votes received.
Okay. And one of the customers asked, where do we get this manual form?
The manual forms are available on the website.
Okay, thank you. And then somebody asked, do we need to submit ID copies if we are changing a cell phone or email, etc., for another director when resigning or appointing a certain director, as we cannot always see this info till we make lodgement?
No, you don't need to submit the ID copy to change the cell phone number or email address, because you can just change that information on the website. So there is no need to submit the certified ID copies of those people who are changing cell phones or maybe email address. That ID copies will only be required when the person is resigning or there is a new appointment of a director. Then the ID copy will be required, which is certified and then valid within 3 months period.
Okay, the next question, you need a death certificate and not a letter of authority appointing executor. I ask, is this new?
Yeah, in a company, we need the death certificate, not letter of authority to appoint an executor. Um, Maybe if I can just answer this question in this way. Practically speaking, the company operates through its directors. Once a sole director dies, a company will be unable to conduct business, and then this will have a negative effect on the business continuity. So if the sole director is also the sole shareholder, there will be no person who will appoint new directors, since directors are generally appointed by shareholders, unless this is specified in another way in a MOI. However, if the director has got a will that specifies the executor, then the Master of High Court will issue letters of executorship to those specified executors, and then if there is no will, the executor will be appointed by the High Court. I don't know if maybe you heard my response.
Can you just please repeat that again?
Thomas, no, we don't we didn't hear you. So I'm just going to ask you to repeat the answer on this question, please.
I don't know if maybe you can hear me now.
Yes, it's fine, thanks.
Since directors are basically appointed by the shareholders, unless if this is dealt with in the MOI of the company. But if the deceased is the director and of new directors. I don't know if maybe you managed to get the full answer on that one.
I think just repeat it for us, because there has been a problem with a mic.
Okay, let me just repeat it again, because it seems we've got a connection problem this side. What I was trying to say is that the company operates through its directors. So once a sole director dies, for example, a company will not be able to conduct business. And this will have a negative effect on the business continuity. So if the sole director is also the sole shareholder of the company, and then there will be no person who will appoint new directors, since directors are generally appointed by shareholders, unless if maybe the MOI of the company states otherwise. But if the deceased left a valid will that specifies who are the executors, the Master of High Court will issue letters of executorship to those specified executors. And then, but if there is no will, then the Master of High Court will have to appoint the executor who will come and manage the estate of the deceased. That will also include the appointment of new directors.
Okay, our next question says, hi team, we need to do a director removal. PIP requested an affidavit. There are 6 directors who signed the affidavit.
If you need to do the director removal, as I've already indicated before, the affected director need to be notified of the intention of his removal in terms of being invited to come to the meeting, to come and answer the allegations labeled against him. So that person will have to come to the meeting and then to come and respond on the allegations. After that, those who are in the meeting will, based on the answer that he has provided, is then that they will vote for or against his removal as a director. So the issue of affidavits, it is not something that is important, because what is required here, or what is important, is for the affected director to come to the meeting to answer all the allegations labeled against him that would lead to his removal. So the issue of affidavit doesn't form part of this process. So I'm not sure why maybe somebody might have requested an affidavit, because we only need an affidavit in a situation whereby you cannot provide the certified ID copy of the person. Is then that the affidavit will also come in handy to explain the reasons why you cannot provide the certified ID of the person. Because remember, once a person is being removed, you find that he's not cooperative at all. And then he will try to not to submit or to disclose some of the information to the company. So including the non-submission of certified ID copy. So in this case, then we will need an affidavit. But that affidavit will be only telling CIPC that we cannot submit the ID copy of this removed person because he's not cooperative at all.
Okay, the next question says, if only updating director's address and or contact number or email, is minutes of a meeting or resolution also required?
No, in the case of updating directors' addresses or contact details or email address, no minutes are required, because setting up the minutes, remember, people need to have a meeting, and then it's quite expensive to have a meeting, because you find that some of the directors are far apart from each other. So people cannot convene a meeting whereby one director, maybe it's in Cape Town, the other one is in Joburg, the other one is in Durban, just to come to a meeting that will costly in terms of traveling, just to come and discuss the change of contact number. So we don't need the minutes of the meeting. So that is why you can go to the system and then update the contact number or the email address.
Okay, our next question, what is the procedure if a director has absconded and cannot be traced?
Yeah, if the director has absconded and cannot be traced, and then maybe the company need to remove that person because that person is not taking part in the day-to-day running of the company, and they feel that he's blocking the progress of the company. So that person need to be removed. So in this case, then they will have to submit the affidavit, as I've indicated before, that this person is not cooperative, is not, we don't know his whereabouts, he's not participating in the day-to-day running of the company. And then, in fact, he's blocking the progress of the company. And then we feel that he needs to be removed. Then they will have to file the affidavit explaining whatever the challenges that they have come across with regard to that director, because that director cannot be traced, and then there are certain documents that cannot be submitted. So the affidavit will cover that omission of certain information that we require.
Okay, how does one remove the initial shareholders if they resign from the company? Currently, it only reflects on the share certificate, but not on the CIPC documents.
Yeah, remember that the shareholders are not on CIPC records. CIPC only keep the records of the directors, not the shareholders. The shareholders will be reflected on the share register certificate of the company. That will show that these are the shareholders of the company. But on CIPC records, we don't keep the record of shareholders. That can only appear on the share register certificate of the company. We only keep the details of the directors.
The next question, I need to remove a director and they are aware of the removal and agree as they're not interested in being part of the company. Which CIPC document do I need?
From the way you have put this question, it looks like these people, they are not being removed. They are being, they just need to resign, because if the way you have put it, that you want to remove and then the person has agreed, so it's better that that person should resign, as a director of the company rather than to be removed, because removal is a different process altogether.
Okay, does this, I suppose, information that you shared also apply to non-profit organizations? I mean, I think they mean non-profit companies, change of directorship.
Yes, the process that we have highlighted, it affects all types of companies, including the non-profit organization.
Okay, they say I've tried several times to resign a director, but CIPC keeps on rejecting my application and requesting a lot of stuff.
Yeah, it's very difficult for this one to respond exactly what was the problem, because you are indicating that they request you a lot of stuff, of which you didn't indicate which kind of stuff was requested. But as I have indicated in my previous slide, that there are certain supporting documents that you need to submit, and then if the application is not approved, they will tell you what is the problem, and then you need to respond on that response from CIPC.
This question, have you thought of communicating with SARS when adding a director to a company, or with the first registration of a company, to have a selection to choose who is the appointed representative of a company? This should be automatically pulled through the SARS system.
No, this one we haven't communicated with SARS with regard to the statement that you have indicated here, because I think, in fact, this statement, I think it relates more to new company registration, because if you add a director to a company, we don't have to notify SARS. But what SARS know is that the change that has been recorded at CIPC, whenever they put in the registration number of the company on their side, it will reflect the latest directors that has been recorded in the company. So I think that is how I can say we communicate with CIP. With SARS, because now they can be able to view who are the current directors of the company.
I want to resign as a director, but CIPC keeps on declining my request, even though I produce requested documents. I think it's the same question we had 2 questions back. I think the person must log a query on the CIPC website, that they can ask what they don't understand, why documents keep on being rejected, and that the specific unit can respond and assist them to submit the correct documents. Then the next question, please demonstrate how to update the director's contact information, email address, and phone number on the website. I was under the impression that we have to lodge a 439.
If you can go to our website and then you log into CIPC website, and then on top there you will select Transact. After that, you will see the selection of various options. At the bottom, I think it's at the bottom line of the icons that you can choose from. There is an icon that shows member, director, contact details. That is where you need to go and click, and then it will give you the process to follow in order to do the change of this director or member contact details.
Somebody says, hi, I have 2 directors that will need to be resigned as they are no longer part of our EPC. I'll be replacing them with 2 new directors. I have all IDs, but one person doesn't want to sign the documents.
Remember, The NPC need to have a maximum of 3 directors. So if you have all IDs, but one person doesn't want to sign the document, then that is fine, because remember, the document need to be signed by at least one director, not all the directors. So only one director need to sign the CR39 form to be submitted to CIPC. So as long as you got the ID copies of the directors, then you can file. So if the person who doesn't, you allege that doesn't want to sign the documents, also refuse maybe to provide the ID copy, then you can submit the affidavit explaining the reasons why you cannot submit the ID copy of that particular person.
Somebody asked, will we have written answers to the above questions? Unfortunately not. Next question, please. Whilst we're waiting, I've noticed that a number of people complain about Home Affairs VAT is down and it's influencing application submission that can't happen. And it's been a few days, we are aware of it. It's a very unfortunate situation because we're very much dependent on the Department of Home Affairs. I unfortunately can't say more than that at this stage. We're hoping they'll be getting back up soon. The next question, what happens when that director is the only director of a company? I don't know if you mean when the person resigns.
I'm not sure what do you want to find out of this statement. When you say what happens when that director is the only director of the company, are you? I don't know.
Okay, just hold on. I see there's another one where she says we're trying to remove a director and there's only the one director. We cannot get hold of him. We sent an affidavit from shareholders, but it was not accepted. Will it be accepted if we have a percentage of a shareholder sign a resolution?
So when trying to remove a director, there is only one director, and then you cannot get hold of him. So that person is the only sole director in the company. And then also maybe the shareholder, I'm not sure. And then now you want to know, will it be accepted if you have a percentage of shareholders sign a resolution? Remember, as I've indicated during my presentation, when you are trying to remove a director, it will depend whether that company has got fewer than 3 directors or is more than 3 directors. If the company has got fewer than 3 directors, and then now the board of director want to remove the other director, in fact, it's another director who wants to remove another director. So that is not possible. Such matter need to be referred to company's tribunal for determination. But if the company has got more than 3 directors, then the process of removing a director, as I have explained in my presentation, will have to be followed.
You'll have to help me whether this is applicable to our present topic. The person says, I've tried to lodge an address change only without a resolution, but your system does not allow it unless you are a director. That is, an agent cannot effect the change without a resolution.
I'm not sure which address you are referring to, because if you want to change the address of a company, you need to do this online, whereby you will use COR 21.1, and then you do all the change of addresses online. There is no human intervention. The system is going to approve your application after a certain turnaround time. And then after that, the response will be sent back to you if that is the change of company address. Because here you didn't specify whether you are referring to the change of company address or to the address of a director. But
Okay, what is the process for director to resign on CIPC and adding a new director, and what is the cost to resign and add a new director?
The process to follow to resign a director on a CIPC, what we need the CR39 application form. We need the minutes of the meeting or resolution confirming change of director. We need certified ID copy of the affected director, and then that ID copy should not be older than 3 months. And then we'll also need the resignation letter signed by that person to confirm that he has resigned from the company. And then there is no cost involved. This is done free of charge.
Do you accept electronic signature on 459 and minute meeting, resolution, shareholder certificate?
Yes, electronic signature is also accepted.
I think we have come to an end of questions because some of them do not relate to today's topic. And I think that's about it. There's nothing for close cooperation member changes. So that's about
Okay,
it.
thank you very much. As per the note here, you're welcome to request copies of the presentations from education@cipc.co.za. I want to thank you for joining our webinar today. We hope you found today's webinar of value and that it will assist you. If you have queries we haven't answered, please log a query on our website that we can answer it. With that, thank you very much for joining and good day.
Thank you.